Thank you, Your Honour. My client is a 14-year-old Torres Strait Islander charged with a single indictment. I submit the evidence, admissions in the police car and during questioning at the station be excluded. The court has a discretionary power to exclude evidence on the fairness discretion and the public policy discretion. It is submitted both could apply. The defence will firstly show the evidence breached the PPRA, the Police Powers Responsibilities Act of 2000, and secondly, examine the two discretions. The evidence. The police breached several sections of the PPRA, including failure to account for the accused's Indigenous culture, improper processes in questioning, in particular ignoring silence and gratuitous concurrence, a breach of Section 420 by not informing legal aid that they had an Indigenous child in custody. A support person of the accused selection was not provided. Under Section 416, instructions by Wendy, the police nominated support person, admissions may be considered a coerced confession. Section 418 was breached as the accused was not informed he could speak to a family member. Questioning should have only occurred when a legal advisor was in support. Breaches exist within sections 435 to 437. Police discussions must be electronically recorded. The accused was not provided with a written copy of what was said and the right to alter it. He was not informed of his right to silence. Regarding the fairness Christie discretion, the court is responsible to ensure the defendant receives a fair trial. I refer to Section 130 of the Queensland Evidence Act. Therefore, Your Honour may conclude the evidence should be excluded as it operates unfairly. The prejudicial effect must substantially outweigh the probative value. The first question, is the evidence slight or insubstantial? Here the evidence is at the core of the Crown's case. The second question, if the answer to question 1 is yes, then it may be excluded if it has substantial prejudice. Here I refer to the Crown and Hasler. In the Queensland Court of Appeal, the Crown and Rogan and Jones confirmed the stated principles by Justice Thomas in Hasler. 1. The judge decides probative value. Here, evidence lacks credibility and therefore has low probative value. 2. Exclusion should only occur where probative value is slight and prejudicial effect is substantial. Presentation of these admissions would have an enormous prejudicial outcome. 3. The only evidence that should be included is that which shows discreditable conduct. The admissions hold no proof of misconduct here. It would be prejudicial since a jury would put more weight on it than it deserves. This is from the Crown and Brown at 32 and 33, Your Honour, where the Queensland Court of Appeal referred to a statement by Justice McHugh in Fester and the Crown. Next, Your Honour, if we look at the public policy island Bunnings discretion, central here is maintaining faith in the criminal justice system. If evidence is gained by police through breaking the law, it should be excluded. The test comes from the ratio in Bunnings and Cross. The court articulated 5 factors which examined if discretion should be exercised for public policy. Firstly, whether the police conduct was due to a genuine mistake or a deliberate legal breach. Here, Your Honour, it seems deliberate given the number and gravity of breaches. 2, if not a mistake, it won't be considered unless vital to the Crown's case and of perishable nature. so they would have otherwise lost the evidence. Here they could have followed the legal procedure and conducted a legal interview. 3. Was the conduct a genuine response to pressing circumstances? For example, was the evidence about to be destroyed? Or did the police just cut corners? Here, the police could have easily followed the law and interviewed the accused at a later time. 4. The gravity of the charges. If serious, the more likely not to exclude. On a scale, the offence here is not negligible, but it is not violent, such as in rape or murder. 5. If conduct breach a statute. Yes, here, Your Honour, several breaches of the PPRA occurred. The purpose of the statute was to prevent such conduct. It was not pressing, and evidence could have been gathered at a later time. Therefore, the evidence should be excluded, given the breaches were severe, wide, and unnecessary, Your Honour. This view is supported by the Supreme Court decision in the Crown and Day. Thank you, Your Honour, for your consideration in this matter.